Okay, hello everybody. We've had some really good questions in about the new furlough process and what that means from a legal point of view. My name's Nia. I'm one of the senior employment solicitors here at Lynn & Partners. We've had to answer quite a few questions on furlough for the last couple of weeks, as you can imagine. And there's constantly new guidance coming out from the government on this. So I would say, with a word of caution, what I'm telling you today is correct today. If you are looking at furlough or want to know how it applies to you personally, do get in touch with us because it does change on a nearly daily basis. But anyway, some of the questions that we've had so far, which I will look to answer for you. The first one is, do I have to prove that the business is facing financial hardship to access the scheme? The answer to that is no. You will require evidence, though, that your staff have been furloughed, so typically a signed letter or some sort of agreement from your staff that they have been furloughed. But it's not. It's available to every business, so it's not linked to particular industries who are having trouble or anything along those lines. You don't have to show your accounts, so you can use it as a way of preparing for problems that you may see in the future, even if you don't currently have them. So no, furlough's open for everybody. Number two, how many staff can I furlough and for how long? You can furlough as many staff as you want. Some organisations are furloughing every single member of staff, others are just selecting the odd one, and we'll come on to the issue of selection a bit later. The minimum time for furloughing a member of staff is 3 weeks. So whilst you can furlough as many staff as you want, once a member of staff is furloughed, they then are in that status for at least 3 weeks. That does give you the option then, obviously at the end of the 3 weeks, of bringing them back or maybe rotating staff, again depending on your business needs. There's no limit how many times somebody can go on or off of furlough, as long as you keep within that 3 week minimum. So, for example, if you've got 30 weeks worth, you could find yourself in a position where you've got sort of 3 weeks on, 3 weeks off several times for one member of staff. Do you need the employee's consent? You need to look at your employment contract, and that's where we come in. In terms of your employment contract, some contracts will offer an opportunity for those staff to be laid off. That was traditionally, before this whole furlough thing came about, without pay. However, most contracts will not have that type of arrangement in there where employers can simply lay staff off as they choose. So on the assumption that's not in your contract, yes, you would need employees' consent because you're changing their status, they're becoming a furloughed member of staff, and also you're probably changing their salary. Although some employers are topping up that 80% to 100, the majority are not looking at doing that. You need consent on those two elements. We're not finding employees being particularly aggressive about this, and most are giving their consent reasonably readily because they understand the process. But people's perceptions now may be very different in 6 months' time. So we do need to make sure that that consent is in place so it protects you in the future. Again, any problems with that, do get in touch. Question 4, how should I decide which staff to furlough? Now, this is actually really quite important because there is a chance going forwards that after the furlough, you've used furlough for a period, for example, or furlough ceases to be an option, many employers may then be looking at undertaking a redundancy process. So we really need to be viewing furlough, although it is very much an alternative to redundancy, and that's the aim of the government, we should really be looking at it very similarly to the start of a redundancy process. So the types of selection processes you should be going through to select staff for furlough should be very similar to those that you would use for redundancy. So, for example, we've dealt with a query whereby somebody wanted to furlough every member of staff that had young children, predominantly female. You can see the discrimination element that could then arise with that. So I think we need to be really careful when we're selecting staff for furlough. We need to be quite objective about it. Ask for volunteers to furlough. I mean, you might find you get too many volunteers, so that might create its own problem. But certainly don't go making any assumptions, and certainly avoid anything discriminatory in that regard. Again, we can offer advice on that. Are part-time workers eligible? Everybody's eligible. If you're on payroll on the 28th of February, they were eligible. The question comes where members of staff maybe have differing salaries, so they're not on a set salary every month. They might be 0 hours, so they've worked different hours over the course of the last year, etc., or then they might be part-time and then get topped up. So any type of employee or worker is eligible for it. The way that they're going to be calculating an 80% grant is they're going to take the highest of either the last 12 months worth, or if they haven't been working 12 months, whatever their average is, or the same month last year. So that will work for seasonal staff maybe, who, because we're coming up to Easter for example, they may find that although their average over the year isn't that high in terms of hours, Easter time last year actually they were working a lot of hours. So that's how they're going to be calculating their 80%. So again, atypical employees who've got slightly different shift patterns should be accounted for in that. Of course, HMRC will have all these records already, so it's too late to change them, and now they are using them. And that's why they set the date of the 28th of February to stop people suddenly changing all their HMRC records, just to really max out on this grant. Can employers still do work for the company where they're on furlough? Now, the key thing here is they cannot be income generating. So if they've got training, for example, apprentices, etc., that can carry on. I mean, the idea is that these members of staff will be useful in a couple of months' time, and that's why they're being kept on payroll. So, yeah, they're allowed to do training, and an element I would suggest of sort of keeping in touch, but what they're not allowed to do is income generate. So you have to be quite clear on that. That's not something that any member of staff can do while they are on furlough. It's actually an essential condition, so really watch that. What if the employer has more than one job? Again, this might be 2 part-time jobs. You might have a full-time member of staff who does bar shifts or what have you to supplement their income. The 2 employers are totally separate. Both are able to get the grant up to the maximum of 2,500. So actually, potentially, one employee could find themselves benefiting twice there. Both employers are going to have totally different set of circumstances. So they could be furloughed from one work place and not the other. That's completely acceptable, and it's expected to a certain extent. So yeah, you as an employer, you're individual. What the employee does outside of that is not relevant really from your point of view. This is whether they're furloughed from your workplace. Now there's some debate around that in terms of can they, if they were just a member, say a full-time staff with you, if they are then furloughed, can they go off and do other work? Certainly volunteering isn't going to be a problem, particularly in the current climate, but whether they can then go off and earn a second salary somewhere else, now that seems morally a little bit questionable, and certainly sort of word from the government is, well, we really would rather people who need work to be able to get the work rather than somebody having to double salary effectively. However, the issue with this is that obviously it could be in their employment contract that they can't have a second job, and that's quite common as a term. So if you as an employer are allowing your employee to go off and work somewhere else, you should look at that contract and let them know in writing that they can go and work somewhere else. And again, consider things such as confidentiality and restrictions. Are they going to be taking your trade secrets away, etc.? So, if you are going to allow your members of staff that ability to go off and work somewhere else, I think that really needs looking at quite carefully, because the whole essence of this is you're paying them to stay available to you. So if you suddenly need them back, how's that going to work? So technically, yes, but from a practical point of view, really do advise you look at your employment contract carefully and really consider what that's going to mean to your long-term cash flow if they're going to do that. Can you bring somebody back from furlough at any time? Subject to the 3-week minimum, yes. So if they're off for 3 weeks and then they come back on, that's absolutely fine. And then you can re-furlough them if situations change. So that might work really well for employers who maybe have projects, so they can project that actually I'm going to need those members of staff for a period. Might even be a week, so they could furlough them for 3 weeks, bring them back for that 1 week, and then furlough them again for another 3 weeks. But there is that 3-week minimum with the ability to bring people back. Just watch your paper trail from an employment contract point of view. If you've changed their terms and conditions, you obviously need to notify them that it's changing again, and vice versa. So you really want to keep a trail of that, because while staff may be very willing to accept all this at this stage, you can well imagine that in months to come, some staff members may feel aggrieved. They may feel that they've worked more than their fair share, or some of their colleagues maybe were furloughed for the entire duration, so sat at home doing nothing, and that's the perception, while they're working hard. So there may be grievances that arise later on down the line, so really do document that agreement every step of the way. The question of can they still work for you? No, they can train, but they cannot do any income generating work. One question we've had quite a bit as well, and this is a cash flow question, so there may be additional people within the group and the area that would be able to assist with this. But my business can't wait until the end of April, which is when we're expecting the grants to start arriving. What are my options? Well, you can create a situation where you do not pay your employees until the grant arrives. And in fact, some employees have written in their contract or their addendum to the contract rather than it's going to be 80% of pay, they're actually saying you will get whatever we get from the government and you'll get it whenever we get it. Provided the employees agree to that, from an employment law point of view, that's acceptable. But again, it's likely to create grievances later on down the line, potentially. So employers are advised to look at things like the business interruption loan schemes and what have you. So they really should be speaking to their accountants and financiers to try and see if there's an alternative way of doing that. But provided you've got the employees' agreement, and we have seen that coming about, potentially, yes, you can make your employees wait until the grant money comes in. One question we've also had is, what happens if I still can't afford to take them back on? At the moment, we believe the furlough process is going to be available until the end of May, maybe a bit longer. And then is there just going to be this expectation on the 1st of June that everybody's cash flow is right back to normal and everyone can come back to work? And I think we all accept that there's going to be a slow change, even post the end of May. Furlough is merely a standstill process. The redundancy process, as would have existed had furlough not been an option, will still be there. So employers may still find themselves in a position come the 1st of June or whenever furlough officially ends from the government, they may find themselves in a position where they then have to go through a redundancy process. And that's accepted, although not really the idea of the scheme is that won't happen, but it's accepted that it may, and redundancy options for employees remain the same. They're still entitled to the same redundancy payment as if furlough never happened. Essentially, it's a freezing of time. That's the safest way to look at it. And obviously the redundancy process needs to be fair and objective and transparent. And of course, if you're basing it on things such as income that they've generated over the last 3 months and half the staff been furloughed, you can see how allegations of unfairness could arise quite easily. So again, if you're looking at that process, do take some specific advice on your situation and just to manage that position. I made redundancies before the scheme. I think a few people probably before the scheme got announced that they started making redundancies because they could see the drop-off. What can we do about that? Can we help our staff in that respect? And they said, yeah, you can actually bring them back on. So if somebody was made redundant, you can bring them back on board so that they can then be part of the furlough scheme. As long as they were on payroll on the 28th of February, that's the key thing. So if they fell between that 28th of February and the point in March where furlough became an option, you can bring them back on board for that to be benefit, and then obviously they'd be subject to a redundancy process later on down the line if need to be. I was planning a restructure before the outbreak, which of course life carries on, doesn't it? Should I use the scheme to delay these non-coronavirus related redundancies? Now this isn't very clear really, but I think the feeling's got to be that when you're looking at a redundancy process, you've got to look at all reasonable alternatives, and I think to not consider furlough as an alternative would potentially lead to an allegation that it was an unfair redundancy process. So whilst the redundancy may have been inevitable before, and we are in a changing world, so I think now that furlough is available, it should go into the pot of options that would be available in any redundancy process, for example, asking people to work less hours or take a pay cut or temporary layoffs. So I think that furlough now has to be very firmly in that pot. So whilst you can continue with your restructure, you shouldn't really ignore furlough as an option because it may provide you just with that short-term break so you can see how your business operates post-COVID. I've had one other question, which is in relation to holidays. Obviously, we're coming up to Easter, so there's a lot of people who've already got their holidays booked, and how does that work? Again, HMRC haven't been very clear about this, and there is a concern that the grant money won't be paid to the full extent if staff are on holiday. And how does that work if it's a 3-week minimum and there's suddenly a week's holiday in the middle? So we're really not clear on how that's going to work, and there is a realistic danger that HMRC will not pay the grant money if somebody's on holiday for the week. They may consider that to be a non-furlough situation. And also, there isn't much benefit for your employees, really. They're already at home, and they can't really go anywhere. So where would the benefit of them continuing with their holiday be present? So it makes sense to scrap effectively or allow them to cancel their holidays. and just remain on furlough. Of course, that then does create the problem that as soon as everything goes back to normal, whatever that may mean in the future, that every member of staff is desperately then going to try and get holidays in, and that's going to cause problems then down the line. They have seen that coming, the government, and they have now allowed employers to roll over holidays for the next 2 years. So the Working Time Directive has just been adapted slightly to allow for that. And I think that's going to be a really key thing for employers, is to really engage with their employees quite early on that, to allow everybody to take their holiday, but to do so in a staggered way so that the business doesn't double suffer by having had the problems associated with coronavirus, and then as soon as everyone gets back to work they all go off on holiday. And suggestions, for example, would be to those staff that weren't furloughed should really take priority, because the whole essence of the Working Time Directive is to ensure everybody takes reasonable breaks. So those that have remained in employment and haven't been furloughed, have probably been picking up an extra load maybe. So it would make sense, I think, from an employer and just from an employee rights element. It just feels morally better to allow those that have been working right the way through to just sort of get first dibs on the holidays. But the Working Time Directive now is allowing employers to extend the period for people to take holidays so that it can be smoothed and businesses aren't unnecessarily impacted upon. But as I say, just in summary, the furlough process is new, it's evolving all the time. The essence of it is to try and allow employers to be in a position that when everything steps back into play, they've still got their much needed workforce there, ready, trained and willing to go. If everybody lost their staff and made them redundant due to cash flow, even if the economy did pick up, they then wouldn't be in a position to really enjoy that pickup. And that's what the furlough process is aimed at achieving. And if you keep that in mind when you're making your decisions, I think that's going to benefit most employers. But anyone struggling to navigate the process, or as time goes on, things are changing, new things are coming forward from the government, particularly charities, for example. They've just recently had a bit of a boost as well. Anything like that, it really is a good idea to get the up-to-date advice from that, and there's plenty of people here to help you with that. So I hope that's been helpful for those of you who are navigating this difficult time. I hope everyone's staying safe, and any questions, do get in touch. Thank you.